My name is Christopher Diorio. I have been a practicing attorney for, what time is it? 33 years now. I started out as a public defender in New York City. If anybody knows what a public defender is, when you hear guys on TV shows saying you have the right to remain silent, you have the right to an attorney, and if you can't afford one, one will be appointed for you. That's what a public defender is. Public defenders represent those who cannot afford to hire an attorney for themselves. When I started out in New York City, that meant that I had a caseload at the age of 24 of approximately 185 cases at any given time. And that's just me as a fledgling attorney. Our office served about 68,000 clients a year in New York City, and the courts are open 24 hours a day, 7 days a week. So if you look at that, we represented 88% of everybody who came through the criminal justice system in New York, 88%. So if that gives you any indication as to what crime is, it is not a racial problem, it is not an ethnic or nationality problem, it is a poverty problem. People who can't even afford it, and they look at poverty as 125% of the federal poverty guideline. Every year the government sets up a line that says if you make below this amount of money, you don't have to pay taxes. You're considered officially poor. Last year that number was $13,783. 88% of the people who came through the court system made less than that. For families, it's 26,000, et cetera. Family of four is about $36,000 a year, and people making below that. Did that for 6.5 years. Got shot by the worst sniper in the Bronx because they had all of this to hit, and they got me in the hand. But after I got shot and I called my wife from the hospital indicating that I had been hit, there was dead silence on the other end of the phone. And 2 weeks later, she took a job up here in Massachusetts and says, "I'm coming to work up here. When you're ready to come, you can come with me." So I stayed in New York. We went back and forth for a few months, and I followed a girl to Massachusetts, and I've been here ever since. The only thing that I love more than as much as my practice, and I continue to practice criminal defense and civil rights litigation. I'm the staff attorney for the National Lawyers Guild here in Massachusetts as well. The only thing I like as much is teaching, because there's far too little knowledge and information about essential things. All of you now have a copy of the Constitution. I teach this stuff at a lower understanding level to kids as young as 4th grade and all the way up into colleges and to folks who are, I think y'all are over 55? Yeah. Great. So just yesterday. Just a little bit. I'm 57, so I drive past the independent living housing developments, and I'm like, oh God, that looks great. Oh, I can live there now. But so many people are out there willing to tell you what your rights are, and what the Constitution says, what the Bill of Rights say, and they're willing to do this because they know that most people don't know this stuff. They may have left this behind when they learned it first in your civics class in the 4th or 5th grade, and then you never really come back to it. And they don't teach this stuff anymore. I have a son who now is a junior at the University of Maine, and I'll ask him about these things, and the only reason he knows anything about them is because of what I've taught him. They spend maybe a week on the Constitution, the formation of the Constitution, and they don't discuss the Bill of Rights at all in high school. And then they set you free on the world, and so that means that there's a lot of folks out there who want to take control of what you understand and tell you what these things mean. And what I tell my 4th graders and my kids constantly is, but when you leave my class, you will know more about the Constitution and your rights than 85% of the adults out there in the world. And sadly, it's true. So I'm happy to continue to come out and start talking about these things to folks so that we all can have a better understanding, and then maybe we can spread the education out to other people and get this out where it belongs. These are just a list of things that we enjoy. as basic human beings. You enjoy watching sports on TV. You enjoy, entertainment in general, listening to music, etc. Going to concerts, going to shows, having productions come in. You love watching movies and television and cable television, streaming services, etc. Watching the Netflix and the Hulu. Reading, obviously, reading books, watching the news on TV, listening to it on the radio, magazines, things of that nature. Love to eat. Love to eat, fine dining, good meals, things of that nature. Traveling, getting out and about, crossing a border, going to another country, going from here to Maine and Massachusetts, wherever it is that you want to go, traveling. And of course, if you have social media, anything that you have access to, Snapchat, Facebook, your kids and grandkids with the TikTok and all the silly dances and stuff like that. Without the Constitution, this is what we have. All of it goes away. Every single thing that I listed in some way or another is affected by some entity or the Constitution itself. Sports and entertainment, we have regulations regarding a number of people that you can have in a venue. We have regulations regarding concussions and healthcare protocols for people. We have watching movies, obviously First Amendment dealings with, what type of things you can put on, what can be done with the news and TV and streaming services and using the Federal Communications Commission and what you can put on the air and who owns the air is all directly related to the Constitution and entities formed by the Constitution. Obviously, reading books and the news and magazines, all within the confines of the First Amendment. Eating, going out, we have the FDA that can say how many bits of spider can be inside a chocolate chip cookie that you buy from a store. That's an actual regulation. There's a rule that says how much of a spider can be in your chocolate chip cookies. None of you are eating cookies today. Traveling, obviously, crossing the border, immigration issues, a big topic right now. Who can come in, who can go out? Who do we allow in? Where do we travel? How do we get out of the country? How do we re-enter? All of these things, and social media, obviously, which is now being looked at potentially as the new public square as far as the First Amendment is concerned. We used to think that you go out and you want to be heard, you want to protest, you want to talk about something about the government, you go to the town square and you get up on a box and you yell and you speak, or you go to the front of City Hall or Town Hall and you stand out in this, usually a rotunda or a square out in front of it, and you make your speech and you make yourself heard. Social media now is becoming the new town square, because you can access millions of people at a time. And there are people now who think that this should be regulated the same way as we regulate speech in public. Here's how it all starts. The United States Constitution is formed in 1787. Prior to, the Revolutionary War begins in 1775, Declaration of Independence in 1776, but the war doesn't end until 1783. From 83 to 87, we're just a bunch of new states under some kind of an umbrella that might be a country that we have a name for. But there wasn't really any way to organize how we ran things. So we had a period of time where we had the Articles of Confederation, which basically just tried to knit the states together in a loose federation of things. But there wasn't really, who pays for an army? Do we keep a standing army? How many people do we keep in a standing army? What do we do about, transporting goods across state lines? How do we connect ourselves as former colonies and now states? In 1787, the Constitutional Convention solved that problem by knitting all of us together. What I have here on this first page is probably one of my favorite pieces of writing. Because if you wanted to know what the Constitution is all about, it's right here in what's called the preamble to the Constitution. Now, as a kid, I learned this musically. If any of you are familiar with something on ABC television called Schoolhouse Rock, where between cartoons, back then they had cartoons on TV between 3 and 5. Good God, I'm aging myself. But between the cartoons, they would have little 2-3 minute songs and vignettes about mathematics and conjunction junction and what's a preposition, and then they'd have this about the government and crossing over. We need elbow room and how we got here, and then they came to this, and I remembered this musically. And so for me, I don't need to look at a screen. I should be able to walk away from this and say to you, we the people of the United States of America, in order to form a more perfect union, establish justice, secure domestic tranquility, provide for the common defense, promote the general welfare and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Thank you. No. It's a busy preamble, but it's all here. Everything that this is supposed to do is right here. And with all of these wonderful thoughts and ideology right here set up in our preamble, what is the most important word? We. Right out of the chute. We. The government does not exist without us. And it's not just us from back then in 1787. It's us now. This is why this is, quite frankly, one of the most perfect, as close to perfect foundational government documents that you're ever going to see. It is the oldest constitution in the world and the shortest constitution in the world. 4,543 words in this document. They were thinking ahead and secure the blessings of liberty to ourselves and our posterity. They were thinking forward. They weren't just thinking into the future 5 years ahead or 10 years ahead. They were thinking about us now. And it's why there are points where it's vague in the Constitution, where you might think, well, the Constitution doesn't say anything about that. And people who are vested in looking at the Constitution as just the words themselves and not what they mean. Folks who are considered strict constructionists or originalists when it comes to reading the Constitution. But they're thinking in the future, and it's vague so that it can grow. The Constitution and all of the rights vested within it are there to live and breathe and potentially to die if we let it, or if we let someone kill it. It is a living, breathing entity that wraps up everything that we are in a paragraph. Powerful stuff. There are 3 branches discussed in the Constitution. Article 1 creates the legislative. Article 2, the executive. Article 3, the judiciary. The legislative branch. First of all, it talks about who can be a member of the legislature. And we have 2 separate houses in the federal government. We have the House of Representatives and we have the United States Senate. Now, House of Representatives, you have to be at least 25 years old. Now, think about when they wrote this, 1787. 25 is kind of like our 40s at this point now. You know, they're on in years. Life expectancy was 45, maybe 50 if you're lucky. They're thinking ahead, and 25 years old, you've got to be a member of the representatives at that point. You're elected every 2 years, so there's constant turnover in the House of Representatives. And it's based, each state has a number of representatives based on the population of that state. So, California, Texas, New York, big states, big populations. They have more representation in the House of Representatives. Back then, it was New York, Pennsylvania, New Jersey was a population center. Massachusetts, kind of. Georgia, pretty big. But if you look deeper into the Constitution, the reason why Georgia was deemed to be a populous state is because they had so many slaves. And there's a point in the Constitution where a slave is worth 3/5 of a person for purposes of counting representation in the government. So Georgia might have had maybe only 1 million or so white property owners. But for every one of these white property owners, there are 10, 15, 20, 100 people in servitude. And each one of them counted as 3/5 of a person. So they were allowed to have larger representation because of their slave populations in North Carolina and South Carolina, Georgia, et cetera. Now, in the Senate, however, you've got to be 30, a little older. And the United States Senate is one of the more exclusive legislative, or in general, one of the most exclusive clubs in the world. There's only 100 members in it at any given time. You've got to be at least 30 years old, and you get elected every 6 years. So there's not as much continuity, not as much turnover in the United States Senate. Now, the Senate differs in that it's not based on population. Each state gets the same number of senators regardless of their size, big or small. So you've got 2 different entities here. Why the 2? Initially, when the Constitution when they're batting around what kind of a government we want to have, well, we're a fledgling democracy. We think it should all be related to population. So, some folks in the larger states, New York and Pennsylvania, etc., thought that it should be one single house based on a number of representatives for each individual state, and that should determine how we go. Democracy rules, majority rules. That seemed fair, yes? But what about states like Rhode Island? What about states like New Hampshire? What about tiny states that don't have as much population? They're always going to be lorded over by the large states. That's not fair. So, the smaller states created the idea of the Senate. At that time, just one representative from each state. Now we have two. But at the time, they said we should have one person from each state come in, and that represents everybody. And they can vote and do things forward. Except that's a minority rule. We don't want large entities being ruled by a small minority. That's not how things should go. And so they bickered over this for quite a while, until George Mason, from the state of Connecticut, came up with what we know as the Connecticut Compromise. And the Connecticut Compromise created what we know now as a bicameral legislature, where we have to get legislation through two separate houses. It goes through what is referred to as the People's House, because this is ruled by population. So you're more likely to have more populous entities having more votes here. This is the People's House. But it also has to get through down here. And this is where smaller states get to have their say. And they can stop things when they need to. And any legislation must pass through both houses before it can get anywhere near the president's desk for signing. So this allows for some degree of balance. And that's what we're hoping for in all of this, some degree of checks and balances so that one part of the government is not lording over all of the others. We want there to be a system of government, that things go through a vetting process. And that's what this does in creating this bicameral legislature. Now, what can Congress do? They can do a lot of things. You look in your Constitution's Article 1, Section 8, it lists 18 separate things that the Constitution can, that the legislature can do. And I've broken them down here in a simpler fashion. First and foremost, they control the purse strings. Whatever budget comes out comes through the legislature. The president can give an idea as to what they want as their budget priorities, but ultimately it comes through Congress. They're the ones who are putting money where it needs to go. They're the ones who are fielding requests from outside entities. They're the ones who control what money gets spent and how it gets spent and where it gets diverted. Okay? They have the power to regulate commerce. At the time, it's taking goods over roads and things of that nature, but because it simply said regulate commerce, that could mean anything. And again, one of the first times where the vagaries of the Constitution is allowed to expand. Because at the time, they weren't thinking about airplanes traveling overseas they weren't thinking about giant cargo ships carrying 1,500 automobiles across the ocean from Japan to here and products from here to Japan. They weren't thinking about all of that, but because they left it open, the language in this document allows for us to think of that. To regulate, they weren't thinking interstate highways, trucks. No, they weren't thinking. They were thinking about horse-drawn carriages going across borders to carry goods from one place to another, when they're talking about regulating commerce. And now we have a humongous commerce industry that is regulated by the Constitution. Immigration laws. The president has nothing to say about who can come in and who can come in and who can stay. All laws related to immigration come through Congress. Everything comes through Congress. They can dictate the laws as to how you are allowed to be entered into the country. They talk about the asylum situation. They talk about anything related to people entering and staying or being made to leave. All of this comes through Congress. It's right here in the Constitution. They have the power to create post offices and to create postal roads. So at the time, they just talk about postal roads. That's, at that point, the old post road extending down from north to south. Now it's the interstate highway system, all coming from the Constitution. There is a mandate in the Constitution for the legislature to promote arts and sciences and to protect authors and artists, but we now know as trademarks and copyrights. But all of it here comes from the Constitution and grants to artistic entities that allow major productions to be done and allows you to go to certain museums because they're funded by federal grants. All of it comes from this mandate that's listed right here in the Constitution in 1787. They're thinking ahead. They have the power to create courts. You might think that the judicial system and Article 3 of the judiciary would do that. No. Article 3, as we'll see, only creates one court. Everything else is the responsibility of the legislature. They dictate where district courts go, what kinds of courts we have, how many appeals courts there are, how many circuits there are for appeals to be heard. They are in charge of that. This is one of my favorites. The Constitution has the legislature has the power to create laws to punish pirates. Important at the time, lots of pirates on the high seas. But again, here's where the language is fabulous. When people go about stealing other people's property, intellectual property, and then publishing it as their own, that's considered piracy. When people are caught, if I buy like a computer and it has an operating system and someone clones my operating system and sends it somewhere else, that's piracy. When Bill Gates steals from Apple computers oh, I'm sorry, I shouldn't have mentioned that. Sorry, Bill. That's piracy. And all of it, when people are going into the movies and sitting down and holding a video camera at their chest to video, the movies that are on screen, and now they don't have to do that. They can just like rip into the publishing, into the studio and steal it and publish it themselves and sell it out in front of the theater for $5 when you got to pay $20 to get a ticket to go inside. That's piracy. And it's right here in the Constitution. Amazing. They have the power to declare war. Congress declares war. The president does not. The president can ask for a declaration of war, and anybody in here familiar with Franklin Delano Roosevelt standing in front of Congress in 1941, he didn't say, we're declaring war. He said, I'm asking Congress to declare war against Germany and Japan. And they did. And that has been the last official declaration of war this country has had. We have had many military operations around the world over in the 80-plus years since. But the last declaration of war was 1941, declaring war against the Axis powers. But we've been fighting a long time. Okay? Congress controls and declares war. And as you'll see here, they create armies, they create the Navy, they create the Air Force. They can also call a militia if needed. But all of that ties back to this very first thing that I talked about. They control the purse strings. If the president decides that they're going to declare wars, or not declare war, but send our military troops somewhere, and Congress doesn't like it, Congress can call them back. If the president says no, under their commander-in-chief powers, which we'll discuss in a couple of slides, Congress has the ability to say, great, no more money. We're not funding this anymore. And so presidents now have to deal with that constantly. It's what's called the Boland Amendment, where they can make the president bring people back. It's been exercised a few times, but not recently. And last but not least, in Article 1, Section 8, Subclause 18, is what's called the Necessary and Proper Clause. What it says is that Congress shall have the ability to create laws and regulations that are necessary and proper for enforcing and putting into action all of these other things that we've talked about. So this clause gives Congress the power to create laws that establish copyright protection, that establish the, what our immigration system is. Subsection 18 has the necessary and proper clause, and it gives Congress tremendous power. Yes?
On there, where it says Article 1.
Article 1, Section 8, Subsection 18.
That design before 8 means section.
The little squiggle,
Yeah.
that means Section 8. Yep. Now, we move on to the executive branch, Article 2. Now, if you look in your constitutions, you'll see that there are multiple paragraphs, multiple sections that deal with the legislature. A long bit. The executive branch, 4 sections, and only 4. And 2 of them deal with eligibility and how we get rid of you. The other 2 deal with power. The president in Article 2, Section 1, the president and the vice president must be at least 35 years old. So they're looking for an old ruler. 35 years old, I still hadn't started investing money yet. But back then, 35 years old, they're looking for somebody with some gravitas at 35. You serve for a 4-year term, no longer than 2 terms, and that's there from the 22nd Amendment. This is a little bit wrong. A president can serve for a maximum of 10 years. But if a term is 4 years, how is that possible? Because a vice president can step into the office. But if they step into the office with more than 2 years of a president's term left, then they can only run for their own term 1 time. So we'll use current day. If President Biden decided 6 months ago that he was going to step down and resign, Vice President Harris moves up into the office. She can run 2 more times on her own because she would have served for less than 2 years of President Biden's term. If, however, President Biden gets elected in 2021 and in 2022, early in 2022, resigns or for whatever reason is no longer able to serve, and Vice President Harris has to step up, she can only run 1 more time. She can run once on her own. Because if she ran the second time, that would push her beyond 10 years of service. So something that folks don't know, they think 2 terms and you're out. Actually, it can be a maximum of 10 years under the 22nd Amendment. There's something else here that's really important. You must be a natural citizen of the United States to be president. This is the only job, the president and the vice president, the only job in the federal system, from deputy vice undersecretary of toilet paper maintenance all the way up to the White House, the only job that requires you to be born here. You could be Attorney General, you could be Speaker of the House, you could be Secretary of Defense, you could be Secretary of State, you could any other office in the United States, elected or otherwise, and you don't have to be from here. The presidency requires that you are from here. Why? Because they hated Alexander Hamilton. If any of you are musical, if you know the musical, Alexander Hamilton was George Washington's right hand for a long time and had tremendous control inside the government, inside the Washington White House. Alexander Hamilton created the Treasury system as we know it right now, created our banking system as we know it right now, established credit for the United States as a whole entity and not a sequence of states. He is responsible for creating our federal system as we know it in general. But Thomas Jefferson and James Madison hated him. Yes?
What about the vice president? He's a high feet away from...
Also has to be a natural citizen. President and vice president have to be. Yes?
What would happen if the president of the House of Representatives became...
A constitutional crisis. It's never happened.
It's never happened,
But they were thinking about these 2 offices. But at this time, when this was drafted, there was no presidential succession. Presidential succession is created in Article 22 and Amendment 22 and Amendment 25. There was no, if this happens, then this guy steps in and so on. There was none of that. They were only thinking president and vice president. So the president and the vice president both have to be natural-born citizens. Because Hamilton was born in St. Croix, Madison and his folk, Jefferson didn't have his hands on this at the time, but you could smell it all over it. But Madison put this in specifically so that Hamilton could never be president. That's how petty these people were. It's fabulous. This is what the president can do. The leader of the free world, most powerful person in the free world. This is what the president can do. The president is commander-in-chief. This is from Article 2, Section 2. The president is commander-in-chief of the armed forces. That's a big deal, right? Very large army, very powerful army. At the time, not so much. But now, huge. They can send troops into certain places, but again, they can't declare war and they can't get ourselves involved in large-scale military operations without congressional authority. They can grant pardons. And this is one of the only things that is completely immune from any control of any other entity in the federal system. The president can grant pardons, and there's nothing that the Congress can do about it. The president can grant pardons, and courts can't stop it. The only thing that is mentioned in Article 2, Section 2 that the president can't do is pardon someone who's been impeached. So if a person has been impeached and removed from office, the president cannot grant a pardon for that impeachment. Now, in our 200 plus years, there's only been 17 impeachments, and only one of them resulted in removal, or two of them resulted in removal, and those were justices on the federal bench. One of them was impeached and removed for being consistently drunk at hearings, and the other one was taking bribes to rule in certain cases. And those are the only two that have been impeached and removed from office. Impeachment just doesn't happen because it's difficult, and we'll see that in a little bit. So the president can grant pardons. It's called a benign prerogative. They can do as they wish and pardon people who are in the federal system only. They can't pardon state crimes. They can make treaties, but they have to have congressional approval. Any treaty that they sign has to go through the Senate before it can actually be approved. They can appoint judges to the United States Supreme Court and any lower federal courts. But in order before those people can do anything, they have to be approved by the Senate under the advice and consent provisions of Article 1. And every year, one time, they have to stand in the well of Congress and declare the State of the Union. And that's it. Those are the only powers of the presidency. That's it. That's all the Constitution says that they can do. And yet, at the end of this particular presidential election, over $2 billion will have been raised and spent by the two people seeking an office that pays $440,000 a year and gives you $150 a day in travel stipends if you need it. So here we are at the judicial branch, Article 3. Article 3 creates one Supreme Court. It's the only court that is specifically mentioned in Article 3. Plus other inferior courts, lower courts, as Congress shall dictate. So that's 13 circuit courts that deal with appeals, and that's multiple district, at least one district court in every state of the union, plus territories around the country and things of that nature. We have district courts everywhere. Federal judges are appointed for lifetime terms. President serves for 4 years, possibly 8 or 10. Representatives can serve 2-year terms, however long that goes. There are no term limits there. Same thing with the Senate, no term limits. There's a lifetime term limit on judges on the Supreme, and it's not just Supreme Court judges, it's district court judges as well. Once you're appointed, the job is yours until you are impeached, resign, or they carry you out of the courthouse in a box feet first. That's it. It's tremendous. It's a tremendous power that the president has in Article 2. Because long after a president is gone for 8 years, if they've appointed, President Trump appointed 191 judges to the federal bench, including 3 Supreme Court justices. President Biden could, if they continue to move on things in the Senate, appoint 193. But they're there for life. And once the president is gone, people who are, the president would not have put these folks there if there wasn't some connection to their beliefs and their ideologies. We have folks that are sitting on the bench right now from President Trump's term that were 35 years old when they were appointed to the federal bench. When I was 35 years old, I had just I just created my first partnership. But there are people sitting on federal judgeships right now that have never tried a case in their life, have never litigated or had their own clients before, and are now federal judges. And the reason why is because they wrote some checks to a particular political campaign and their supporters. And they got their names on a list, and now they're judges for life. And they're true believers, which means 10, 15, 20 years from now, that's important. It's also important because the Supreme Court says what the law is. But they also dictate their own caseload. You can see right here, Marbury versus Madison in 1803, Article 3 didn't say what the power of the Supreme Court was. It simply created a court, but it didn't tell them what their jacket meant. It didn't tell them what their powers were. So the court made them up themselves. In Marbury versus Madison, they said, at the time a throwaway line, but is now the line that creates their power. It is emphatically the providence of the Supreme Court to say what the law is. The Supreme Court says what the Constitution means. They interpret what the laws mean. And that's important because they also dictate how many cases get before them for them to make decisions. Last year, in the 2023-2024 term, there were 8,782 cases that were appealed to the United States Supreme Court from lower court decisions, appeals courts and district courts. They heard arguments in 81 of them. 81 cases they heard arguments in. Now, it's important that they make decisions on certain areas of law, but when they don't decide to hear a case, they've also made a decision. What that means is whatever happened at the lower court level is the law. They're saying there is no conflict here. We don't want to get into this. So whatever that Superior Court judge said, whatever that district court judge said in Alabama, that's the law regarding transgender rights. Whatever that judge said in Texas regarding access to health care, that's the law. We're not getting into it. They'll only wade in when they want to. And that means that whatever happens at the lower court stays. And that's why putting judges on the bench that adhere to your ideology is tremendously important. Because if you put judges at the lower levels that believe in what a president from 25 years ago believes, that's a ripple effect of your presidency going out into decades. You put somebody on the job at 35, they're going to be there probably until they're in their 70s or 80s. We've got 3 judges on the Supreme Court right now that are in their 80s that have been there since the 90s. Yeah.
Is that why there's the odd number as a safeguard?
You know, that's something else that was not inside the Constitution. They didn't say how many judges are supposed to sit on the court. Congress decided. And so when you talk about folks saying, oh, well, we need to expand the court, oh, that's a radical idea. It's not a radical idea. The composition of the United States Supreme Court has changed 18 times. It's been 9 for a long time. But before that, it was an odd number. And before that, it was an even number. The first court had 6. It's at times been 11, and then 7, and 13, and 7 again, and then 9. And it's been 9 for a long time. But Congress controls how big the court is. Right? Yes?
Can they also change other things under that judicial system?
As long as it's within their purview. I mean, like I said, Congress controls the courts and what those courts do, and they control the regulations around those courts. But inside the judiciary, they can also create rules and regulations as to how they act. Right? You see now in the United States Supreme Court, they're discussing about a code of ethics. You would think that Supreme Court justices would already have a code of ethics in place. No. They've only had a code of ethics for a year and a half now. And only because people started talking about judges taking hundreds of thousands of dollars of gifts from people that, oh my goodness, they also happen to argue in front of the Supreme Court and maybe might want to influence a decision.
So how many times have they made changes to the judiciary?
Oh, goodness. At this point, too many to count. It's a lot.
Congress.
Yeah. They're constantly changing things within the confines of the Judiciary Act. Little things that we don't really see, things that affect my practice, things that when I'm in, that I have to deal with. They regulate how, when you file a document, how thick the binder can be. Right? Like if it's more than 1.5 inches thick, I have to create 2 binders. I can't create a binder of 2 inches. I have to have a binder that's 1 inch or 1 inch or 1.5 inches and 1/2 inch. I have to dictate, and then I'm only allowed to use a certain typeface. And all of those are things that Congress actually sits down and thinks about. Typeface and what my spacing has to be and what my margins are on documents that I file to the Supreme Court. And I always remember, as I'm going to talk about in a little bit, Gideon versus Wainwright that created Supreme Court case that created the right to counsel for everybody in a criminal case. And Gideon wrote his appeal to the United States Supreme Court in a pencil without an eraser, by hand, because he had no representation, couldn't afford one. And so he wrote his own United States Supreme Court appeal in pencil. When I see it, I well up a little bit, because that's just really what we're supposed to be, is the people having access to courts. Now, the Bill of Rights is what people talk about. They don't talk about the Constitution, that's fine. But there were 39 people of the 43 delegates that signed the original Constitution. 4 of them refused to sign. And the reason why they refused to sign was because they didn't include individual rights in the Constitution itself. The only thing that discusses the rights of an individual in the actual Constitution is the right to habeas corpus, being brought, the right to be brought before a court, and that's it. They had to create a Bill of Rights. So what they did was kick the can down the road for a few years. So in 1791, they got around to crafting the Bill of Rights. And again, this is James Madison doing this. Ratified in 1791. Originally, there were 12 amendments. Now it's just 10. 10 were the ones that survived. One of the two that failed to make it was something regarding creating the actual postal service inside and dealing with the rights of people to post mail, which you would have thought was done in the Constitution itself. No. The other one was the creation of the Internal Revenue Service. They didn't like that, so they got rid of that. They left it for a Congress long after that to do. So we have 10 amendments that were actually approved. And this was a response to the states that wanted them to be there, but they weren't actually put in, because if they were, a lot of southern states would have walked away. We wouldn't have had the majority that we needed to get this Constitution up and running. Now, a lot of amendments, as we go through them, I'm going to say that they're busy. What I mean by busy is there's a lot in them. I can sit here and talk with you for an hour or more just about this one. I can give you 8 hours on this one. I can break this down into small sections and give you 8 hours on the First Amendment alone. But the First Amendment is a busy amendment. It deals with your right to practice religion. It's what's called the Free Exercise Clause. You can do as you wish to practice your religion, and there's nothing the federal government can do about it. Unless your religion is such that it violates the rights of others, because you can't sacrifice a virgin at the lip of a volcano to have free exercise of your religion. Not good. And more to the point recently, you're not allowed to ingest certain hallucinogenic drugs in order to bring yourself closer to God. As you see, Native Americans and indigenous people who are ingesting peyote and other types of drugs inside sweat lodges and having, God visions and going on walkabouts with God, that's a federal, you can't take those drugs. They're federal, it's federal crime to take those drugs. But the federal, you are only allowed to practice your religion up to a point. Same thing with the second thing. Government can't force religion on you. That's more traditionally referred to as the Establishment Clause. Basically, government cannot say that there is an official religion or no religion at all. They can't tread on that, except if any of you has any money in your pocket, take it out and tell me what's on it. On your coins and on your paper money. When you go to the State House at the beginning of the State House legislative year, when you go to the Congress at the beginning of the legislative year, what happens? A person comes out before they start to talk about the law and gives a benediction or a prayer. There's actually an office in Beacon Hill for the chaplain, which has never been occupied by anybody other than a Christian. And same thing in Washington, D.C., right? And there's actually no rule that says you have to. I could take my oath on top of Harry Potter, Volume 8, if I want to. There's nothing that says it has to be Bible, but it always is. I'm waiting for the first president that decides they want to take their oath of office on the Quran and see how many heads explode. But so government can't force religion on you. And it's not just that if you go to your town hall meeting. If you go to your town meeting, there's always a prayer beforehand. There's that moment of silence. Now they do it a moment of silence before your select board meetings. It used to be a prayer, right? Freedom of speech. You have the right to speak. What is speech? Is it just things that are verbalized? Is that it? If you ask me a question, a yes or no question, and I do this, what does that mean?
Yes.
Have I said anything? But I've expressed something, yes? Freedom of speech also means freedom of expression. If I want to wear a black armband to protest the Vietnam War to school, I'm allowed to do it. It's considered expression. Students don't leave their rights at the schoolhouse door, right? If I want to wear a vulgarity on my jacket in the Supreme Court in California, I can do it. My speech is protected, even though that speech may be vulgar. Justice Douglas years ago, one man's vulgarity is another man's lyric. Wonderful sentiment. You have freedom of the press, but what counts as the press? At the time when they, again, part of this tremendous ability to expand and grow. Back then, the freedom of the press is a guy with a printing press rolling paper out and printing maybe 50 papers in a day. Now, it's the internet. Now, it's every little tickle that I get here that says that the president did something silly and the other president is a buffoon, and all of these things, they come through on a 3x5 box. It's amazing. And magazines and newspapers and cable news, all of that deals with freedom of the press. But how far is the press? Where does it stop and where does it begin? Tremendous expansion and growth here in the Constitution. The freedom to assemble and the freedom to protest about the government. Where can you assemble? How can you assemble? You're allowed to do it on public streets. Where does the public street end and where does private property begin, and who can control what and when? All of these things are embedded inside the First Amendment. Second Amendment, not so busy, no less confusing. You have the right to keep and bear arms. I refer to it as guns, but then I put a question mark there. If you have the right to keep and bear arms, and people are traditionalists and they look at the document, they look at weapons of war. At the time, long rifles, single-shot handguns, things of that nature. If you deal with the expansion of this now, the freedom to own, keep and bear arms extends to magazine, high-powered automatic weapons, semi-automatic weapons, things of that nature. Does the right to keep and bear arms extend to me having a surface-to-air missile that I can shoot that because these damn planes going to Logan, ping, interrupting my sleep? Does that count? Is that protected? Where does regulation, where is it allowed to begin and end? Right? There are people who are absolutists who say the right to keep and bear arms means everything. Everything. I can walk into Grand Central Station with a dirty nuclear bomb in my suitcase, and that counts. Unless I'm brown, then it doesn't count. Right? But the right to own arms. But they forget also about the beginning of the amendment. Again, if you look at the document in front that I gave you, it says a well-regulated militia being necessary to the security of a free state, comma, the right to keep and bear arms shall not be infringed. If you go to NRA headquarters in Washington, D.C., in the stone across the top of their building, the quote begins with the comma. The right to keep and bear arms shall not be infringed. The whole beginning is gone, as if it doesn't exist, and yet it is potentially controlling as to why we have the right to bear arms and what kinds of arms are we allowed to have. Right? Justice Scalia, in writing in the case of McDonald versus Chicago, answered this question temporarily by saying that the Second Amendment is to be protected the same way any other right is to be protected, as an individual right. And therefore, the right to keep and bear arms shall not be restricted unless. And then he goes further and says, as he had said in countless other decisions before, no right is absolute. So if there's a reasonable, rational regulation that the government needs to have regarding weapons and arms, they can try to have it passed, and we'll see what happens. Justice Scalia never saw a regulation that he thought was constitutional, and then he died, and his successors haven't seen one yet either. But that's a question that remains. What can you do? We just saw last year that the law here in Massachusetts and other places that say that the chief of police is responsible for saying who can get a license to carry a weapon, that is under question now, because that authority is deemed to be unconstitutional. The Third Amendment, I keep it here just because it's funny. The government can't put soldiers in your house. Not a big deal now, very big deal back then, because when the British came over here, they took over farms and they took over households and said, we're putting our people here and we're going to eat your crops and we're going to take your animals and we're going to use the horses in the war. They quartered. This is the quartering amendment. You can't put the military in your homes. It has never, ever been discussed in the United States Supreme Court. The Third Amendment has never been argued over. It's only appeared in the federal system twice. One of them was where the National Guard unit tried to take over a motel in Utah. and the motel owner sued and said you're violating the the Third Amendment, and they were right, and it never went any further. The Fourth Amendment. Here's another busy one, and it's busy because it's potentially confusing, but the confusion is good. It's a good kind of confusion. There are no unreasonable searches of your person, your house, your papers, or your effects without a warrant. Seems relatively simple, right? No unreasonable searches of your person. What counts as your person? Where does your person begin and end? Right? You have a bag right there. It's touching your leg barely, but not actually touching you. Right? Can I, as a law enforcement officer, go and take that bag and search it?
I would hope no, but I'm guessing it's yes.
Potentially, yes. Right? Now, because it's within your custody and control, though, it's considered part of your person. Right? You have access to it. Now, my bag is way over there. If I'm standing over here and law enforcement comes in and takes my bag, do I still have custody and control over that bag? Technically, no. Right? They can argue I've left it there. Countless times people will, try to get, if they're being chased by law enforcement, they'll have something illegal in their hands and they'll throw it. Right? It used to be part of my person. When I throw it, I've abandoned it. Now they can take it. When you put things in your garbage, the government can search your garbage because anything you put in the trash is deemed to be abandoned. You no longer have custody and control over it. Right? Your house, what counts as your house? Who has an attached garage at their home? Is your attached garage part of your house for purposes of search? What if you have a detached garage? What if you have a shed in your backyard? Is the shed part of your home? What about your driveway? What if the police get a call that says they're looking for a vehicle that was involved in a hit and run accident? And they have a general idea and they have like a tire type that they're looking for. And the police pull up to your driveway and there's a car under a tarp in your driveway, not in your garage, but on your property. Can the police go up to the car, pull up the tarp, and see the bloodstains on the front of your car, and then come in and arrest you? These are all issues that you have to deal with when you're talking about what the Fourth Amendment covers, right? Your house, your papers, or your effects. Folks still have file cabinets in your home, boxes that you keep papers in? I have this. And Supreme Court decisions and federal judges have said that this is the modern day equivalent of the file cabinet. All of my important phone numbers, all of my important papers, messages, pictures of people that I love and some that I don't. And you got to keep receipts, folks. But are here. This is the file cabinet of my life. Can law enforcement make me open this to search it? To look to see if I'm involved in dealing with drugs and they want to see if I have the phone number of a drug dealer in my phone. Can they do that? What if it's one of those things that has Face ID? Can they they can't make me open it, but what if they take my phone and hold it up to my face really quick? And then it opens. Is that allowed? Or thumbprint IDs or things of that nature? I'm going to, public service announcement, turn off your touch IDs, turn off your face IDs. Just, you'll thank me if it ever happens. It doesn't look like a whole lot of lawbreakers in the room, but just in case. Pass that on to your nasty grandkids that are doing stuff that you don't like. The Fourth Amendment discusses a warrant and how to obtain it and how to get probable cause to do it. But the Fourth Amendment is the first discussion of the right to privacy. It's the first real inkling that there might in fact be one. And I say might in fact because technically there is no constitutional right to privacy. 4,543 words in the Constitution. Another 2,000 in the 27 amendments that occur after it. The word privacy will not be found anywhere. But we have a right to be free from unreasonable searches of our person and of our homes and of our cars and of our garages, detached or otherwise, and our shed that's on our property and our driveways and our bags. We have that. What is that if not privacy? There's a certain area, an aura around us, a bubble in which that we should be safe from the government. It starts here in the Fourth Amendment. The Fifth Amendment deals with, any of you remember, I grew up with Dragnet, right? Just the facts, ma'am. And then, Harry Morgan, Jack Webb tells Harry Morgan, read him his rights. And you hear the right to remain silent, right? The right to remain silent is there in the Fifth Amendment. And that refers, same way I talked about with the First Amendment, expressive language is also considered something protected, right? If somebody gets a confession beat out of them and they put up a thumbs up, that's still considered an unlawful confession because they expressed something. They don't have to say it or write it, okay? Fifth Amendment also protects against double jeopardy for crimes. Here's the example. Karen Reed, those of you familiar with Karen Reed, she owes $5 million to her attorneys, poor baby. She goes to trial in January, and the jury, after having a mistrial in the first trial, the jury in the second trial finds her not guilty. Karen Reed walks out onto the steps of the courthouse and says, "You bet your ass I killed him and I'll do it again. I'd run over him twice if I could." There is nothing they can do about that. They cannot retry her. New evidence comes up. She confesses. O.J. Simpson comes, before he dies, if he gets on camera and says, "Yep, I did it. Didn't like that she was dating that guy. It's like a dog peeing on a tree, that she's mine, nobody else can touch her." Right? And he had goofy hair, so I killed him too. But there's nothing you can do about it. Double jeopardy, you can't punish someone twice or attempt to punish someone twice for the same crime. You get one bite at the apple. The government gets one shot. Sixth Amendment, here's another busy one. This is the one that the attorneys love. You have the right to a speedy and public trial. Speedy trial means you got to get in front of a judge as fast as is possible. Okay? Public trial means they can't, unless it's a juvenile, they can't sequester your trial. Okay? The public has access to the room. Impartial juries. You're not allowed to seclude or exclude from jury service people from one particular racial group or a particular gender or a particular identity or nationality. Impartial juries means some degree of balance, and you have a right to choose who sits on your jury. Okay? You have the right to confront witnesses. This is called the Confrontation Clause. This dates all the way back to Shakespeare, and if you want to really go into it, dates all the way back to the Bible. You talk about people who created the right to confront witnesses after the Star Chamber in the 1500s hearkened to the Bible itself to talk about how Jesus, when questioned by the Pharisees, chose to remain silent and then asked to speak to those who spoke against him. Right? This can be a 2,000-year-old right, it can be a 400-year-old right, but we now have the right to confront any witnesses that are brought against us by means of cross-examination, the greatest tool ever invented to deduce truth, according to Justice Harvey Blackstone. And you have a right to counsel. As I mentioned earlier, Gideon versus Wainwright creates this right. Initially, you had only the right to counsel in capital cases. So that meant if you were charged with anything that wouldn't result in life in prison or in the death penalty, you weren't entitled to an attorney. You had to go get one your own. And Gideon was a lifelong criminal, a minor criminal. Not like, people thought that the character in Cool Hand Luke, if you remember the movie, knocking the heads off of parking meters and taking the money and going to play pool, right? People thought that Luke was based on Gideon, because Gideon was just a gadabout, spent most of his life inside and out of jails and things of that nature. But they had in Mississippi a 3 strikes clause, one of the first states that had it. And his third felony for knocking the heads off of parking meters resulted in a life sentence. But he wasn't entitled to an attorney. He had to represent himself for his own life. Had to represent himself. And so he had to appeal his own case in handwriting. And ultimately, I encourage you, go Google the Gideon Appeal and look at it. It's written in the pencil-written handwriting of someone with a 4th grade education who appeals to the biggest court in the land and says, "I should have had an attorney. If I had one, I could have done better. And people like me should be entitled to counsel." And he won. He won with a pencil-written appeal. Everything that you want to be, everything you want the justice system to be as an attorney was right there in that handwritten appeal. It moves me. I'm welling up right now. The Seventh Amendment says you have the right to a jury trial in serious matters. When I refer to serious matters, at the time they wrote this, anything that was worth more than $20 was deemed to be a serious matter. That has not changed. There are specific regulations that deal with jurisdictional limits now at the state and federal level, but $20 was what they deemed to be a serious matter. The Eighth Amendment says that there should be no cruel and unusual punishments or untoward bails. This, when you're talking about the death penalty and torture, this is what they're talking about. No cruel and unusual punishment. And again, this is the power of having judges that are appointed and then off the bench at any given time. In 1976, the United States Supreme Court, citing the Eighth Amendment, said that the death penalty was unconstitutional. In 1978, they said it was. It took them 2 years to change their mind. What happened in those 2 years? 2 judges left the bench and 2 judges were replaced. The Supreme Court, I'll go backwards a little bit with this one. The Supreme Court is not final because they're right, but they are right because they are final. They have the last word. It's emphatically the province of the United States Supreme Court to say what the law is. So when they say it, that's it. But see me a few years from now when the court composition changes, and the law may change as well. That's why, again, it grows. The Ninth Amendment and the Tenth Amendment are important, and nobody ever talks about them until they need to. The Ninth Amendment says that just because rights aren't listed in the actual Bill of Rights doesn't mean that they don't also exist. And again, we're talking about the right to privacy. This is what Justice William O. Douglas, when he crafted privacy in Griswold versus Connecticut from 1965, this is what he used. It's what he called penumbral rights. We have rights that aren't stated, but we cannot possibly deny that they exist. The right to live, the right to breathe, the right to expand ourselves, the right to the things we talk about in the Declaration of Independence, the right to be happy, the right to pursue. It says pursue happiness. The original, when Thomas Jefferson plagiarized it from Jean-Jacques Rousseau and John Locke, yeah, I called Jefferson a plagiarist, stole it. It said the right to pursue property. In the Declaration of Independence, it says pursue happiness. Happiness equals property. You figure it out. But just because it's not written doesn't mean it doesn't exist. So the right to privacy that was created in Griswold, for the first time, judge-created law, uses the Ninth Amendment and the Fourth and the Fifth and the Sixth and the First to talk about this right to be free within ourselves and among ourselves, to have this degree of privacy. And the 10th Amendment says, if the Constitution doesn't give a power to the federal government, it belongs to the state. Now, if the federal government decides that they want to step into an area, once they do, under Article 6, their law controls. So prior to 1965, individual states regulated cigarettes. And then in 1965, now you've got labels on the side of cigarettes, now you've got labels on billboards, now you've got, that comes from federal law. What that means is federal law controls. It hurt a lot of people because it meant that if you sued somebody in a state court for a wrongful death as a result of cigarettes being poison and them knowing that it was, the case would get dismissed because the federal government controls, which meant all these people had to now sue people in the federal system, which is a lot more expensive and a lot more time consuming. And lawsuits failed for a long time until people got smart and the Big Seven lied in front of Congress. There are other amendments that come after the 10th. The 14th is probably one of the most important. It's important because all of those first 10 amendments that we discussed only restricted the federal government until we get here. 14th Amendment says that states can't deprive people of their rights without due process, and it refers specifically to states, and that states cannot deny equal protection of the law. This is the first time equal protection is discussed anywhere. 1865. 13th, 14th, and 15th come directly after the end of the Civil War. And this applies the Bill of Rights to the states as well. It's what's called the Incorporation Clause. That anything that the federal government can't do, the states can't do to their citizens as well. Other important amendments, the 13th. For the first time, the word slavery is discussed in a federal document. It had never been mentioned. Word slavery is not in the Constitution. It refers to people indentured in servitude and other individuals. Other individuals means slaves. Because there were slaves, and there were also people who were sold into servitude. You serve 10 years, you serve 15 years, you serve 20 years to pay off a debt, and then you're done, and then the person can sign you out. They can give you manumission if the debt is paid. Other persons, when they were talking about the 3/5 clause, dealt with slaves. But the word slaves is never mentioned in the actual body of the Constitution, and in the first 12 amendments was not mentioned either. 13 is the first time it's mentioned, abolishing slavery, except if you are a prisoner. If you're a prisoner at the state and federal level, the 13th Amendment doesn't apply to you. You can be made to do things for no money or very little money. You can be made to work. The minimum wage at MCI Norfolk was 75 cents a day for doing actual work, like a 6 to 8 hour day of work as a prisoner, 75 cents a day. 15th Amendment creates the right to vote for all citizens, both naturalized and others. That meant slaves. Oddly enough, it took another 100 years for that right to actually come to fruition with the Voting Rights Act in 1965, signed by LBJ. The 18th Amendment banned alcohol. Remember Prohibition. Well, nobody in this room remembers Prohibition, but so be it. But banned alcohol. Why is this important? Why do I talk about it? Because of the 19th Amendment. 19th Amendment grants women the right to vote in 1920. All of the people, most of the people behind the banning of alcohol were women's rights groups. Women's Christian temperance movement, right? Southern women, for abolition. All of these groups of women, hundreds of women got together, moved their churches, moved their pastors, moved people in the streets. They marched down streets in their dresses and giant hats and marched down the streets to ban alcohol. And they got it done because someone in Tennessee didn't believe it could actually happen, and they went ahead and voted for it because they thought other people weren't going to vote for it, and they were wrong, and it happened. But all of these women had tremendous power for the first time. And they all sat around and said, we got this passed and we couldn't vote for the people who passed it. Let's change that. And they used this tremendous machinery that they had created to ban alcohol and went out and got themselves the right to vote 3 years later. Tremendous, tremendous movement. Fabulous. The 18th is great because of the 19th. That's it. The 25th Amendment is also important. What happens if the president can't do their job or if they pass away? Because again, that was never mentioned in the Constitution itself. Important because it creates the Presidential Succession Act and allows for the discussion of who comes in after, if the president, then the vice president, if the vice president, then the Speaker of the House, if not the Speaker of the House, President of the Senate, and so on. And it goes all the way down to the Secretary of the Interior, last in line. Alexander Haig was incorrect when he says, "I'm in charge." Back when Reagan got shot. He was not in charge. He was fourth in line to be in charge. But this also deals with what happens if the president is unable to perform their act. It's only happened a few times, usually when the president goes into surgery or if there's some sort of a tragic act. It happened when first President Bush had surgery. He signed 2 letters, and this is how it works. You can do this voluntarily, invoke the 25th. If any of you are West Wing fans, the folks on the television show The West Wing, you also saw it there. President signs 2 letters. One saying, I'm no longer, at this point, from this point forward, I am incapable of executing the office of the president. I hereby cede powers of the presidency to my vice president. Signed, X. And the second letter is, I no longer have the incapacity, and they send that to the Congress, and then you're back in office, okay? There's also a provision here in the 25th Amendment, the third section of the 25th Amendment, that says what people can do to remove a president. It was discussed during the closing of the former president's term. The notion, it's been discussed by folks regarding this president, if they can't do their job. The vice president and a majority of the cabinet can sign a letter saying that we believe that the president is no longer capable of serving in office due to an infirmity, during incapacity, whatever. They then take that letter and they send it to the Congress. And at that point, the president is removed from office. The president then, according to the amendment, can sign his own letter saying, nope, I'm good, and send it back to Congress, and then he's back in office. And then the same people can say, no, 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 you're not. And they sign a third letter, and that goes to Congress, and that starts a trial. Same as an impeachment, where you have to go in front of Congress and you have to prove that you're capable of serving in office, or the people bringing this have to prove that you're incapable of serving. But the mechanics are there. People ask me, well, what do you know, how do we get rid of a president if they're elected? Do you have to wait 4 years? Technically, no. But it requires there to be some degree of incapacity. Now, all of this may seem theoretical, but it actually applies. It applies to you every day. Now, what if you decide to go to a protest? A person of color is murdered at the hands of police, and you decide to wear a black armband on your arm? Can your boss suspend you or send you home for your protest? Yes. Why? Because your boss is not the government. Private individuals can do as they wish. Your boss can choose what you do in your office or not. What if your boss is a major federal contractor? Can they do it then? No. Because inside most federal contracts is language that says that you agree to abide by certain provisions, one of them being we're not going to stifle the expression of our employees. Right? What if you staged a walkout? Same thing. Right? If you stage a walkout and get everybody to walk out of work for a day, your boss can fire you. Private individual can fire you, but if your boss is connected in any way to the federal government, or if they're a state contractor here in Massachusetts, they can't do it. All of these rules, all of these amendments affect what the government can do, not private individuals. Right? What if you wore a curse word on your clothes in protest? Right? Again, difference between public and private. What if you wanted to write about these protests around the country and you put it on a social media account that you had? Can you be punished for that? Can the social media company censor your opinion? Right now it happens all the time. 1 out of every 10 things that I write on Facebook or whatever gets censored because I violate the provisions, because I'm talking nasty about people that I think are horrible individuals that shouldn't be involved in the government. But it happens because it's a private industry. But the discussion now that's going to the Supreme Court, probably this term, maybe next term, is whether places like Facebook, places like Instagram, places like X, formerly known as Twitter, are the new public square. That this is how we express ourselves. And if that's the case, they shouldn't be censored. And you see already now that individual states are trying to remove the ability to censor people. They want they want expression out there. They want their views out there, even if it's false information, if it's misinformation, if it's disinformation, it's speech. John Milton talked about the marketplace of ideas. Let's let forth all ideas forth upon the marketplace and let truth win out. Belief that truth would ultimately win. But then Stalin talked about repeating things so often that they become the truth, even if they're a lie. Right? How does that, how do those things connect? What if you're receiving Social Security or SSDI or something of that nature? Can the government make you take a drug test in order for you to maintain your eligibility? What do you think? It's an intrusion. That's considered if you've given them no reason to believe that you are under the influence of anything, that is an unreasonable search and seizure. Giving blood, giving urine, giving whatever, hair follicles, right? No, well, not me. Giving hair follicles is it's a search. It's your body. Remember the Fourth Amendment. You have a right to freedom for your bodily autonomy. It's a government entity asking that. What if it were a private annuity? What if it were something that you contributed to as part of your job, and it was a private annuity or private, like a 401k or some type of investment plan run through your employer, a private entity, can they make you take a drug test in order to confirm that?
Maybe yes or no, depending on whether or not they have kind
If they're not a federal contractor, they can make you take whatever test you want, and then it's up to you. You can either choose to take the test or you can leave. Right? They control. Can law enforcement search your home even if you've never given them reason to believe that you've broken the law? Can they just come in and knock down, come in, push their way in and search your house? Only with a warrant, unless there's an exception, if you give them consent, or if they're chasing somebody into, if you're running into your home and it's hot pursuit, they can chase you into your home, technically. They have to prove the hot pursuit. What if you're renting the place? Can your landlord let them in?
No.
Your landlord can let them in. Recent Supreme Court decisions say that even someone who is not a renter of the home, if the police believe that the person who answers the door has control over the home, if it's your house and your nephew is staying with you, and they've not signed a lease, they're no part of this, the nephew's in the house, the police knock on the door and say, "Can we come in?" And the nephew lets them in. The nephew has no rights to this house. But if the nephew lets them in and they find a pile of guns in the back of your house in the closet, and they arrest you, and you say that's an unlawful search, they're going to respond with, "We had consent to enter from someone that we believed reasonably to be a member of the household." It's allowed, right? Especially if it's a landlord. Landlord controls the home. They can open the doors. Check your leases to make sure that they can't. You got a 17-year-old granddaughter driving her car, police officer stops her and writes her a ticket for texting while driving. She denies it. The officer takes the phone out of her hands because she's like sitting there texting while she's being accosted by the officer. I got two in their 20s. It happens. She denies it, and the officer takes the phone out of her hands and puts her thumb on the Touch ID and opens the phone, and it shows that she sent a text message within a minute of being pulled over, right? That she was in fact texting. Is the officer allowed to do that? No. Remember, this is 4th and 14th Amendment protected, right? You have rights to to protect yourself from an unreasonable search of your papers and effects. This counts, right? Your glove compartment counts. The trunk counts, right? All of this counts, right? This all affects you. It might seem that it doesn't, but it does. It affects each and every one of us every day. And it's the reason why I gave each of you a copy of the Constitution and the Bill of Rights to have. If you went out and bought furniture from IKEA, God bless you, first of all, but you brought it home and you open up the box and the wood pieces spill out and there's the bag of nuts and bolts and the little Allen wrench that's going to assemble this giant thing, and the instructions in Swedish and English. If you took the instructions, crumbled them up and threw them in the trash, how smart would that be? Not smart at all. You buy a new board game, you buy a video game, you buy something like that. I use this with the kids. And you buy the game and then you take the instructions and the rules and you just crumple them up. You just make it up on your own, right? How smart is that? Not. People throw away their rights every day by not understanding the rules of the game. The rules of the game are in your hands right now. It's right there. What the government can and cannot do every day is right there in that document. Everything. It all bound up in that preamble, but laid out explicitly, right there in your hands. Why would you play the game and be successful at it if you don't know the rules? Unless you're going to make the rules up as you go until someone tells you, no, those aren't your rights, these are. And if you don't know any better, you'll do what they say. Most people will succumb to that because if people tell them with enough force, they'll believe it. There's no excuse for you now. You have these things in front of you, right? Don't be afraid of it. You know, these are the rules of the game. And every once in a while, you got to punch a bully in the nose. And they don't like being told that they're wrong. They don't like being told, these are my rights and here's why. And it applies to both sides. Know what the rights really are. And then do what I've been trying to do for the better part of 15 years now. Over the past 15 years, these constitutions that you have in your hands, I've given away over 11,000 of them now. To school kids, to school systems. I could show you a picture if I had the speed to do it, of me putting one of these in the hands of Hillary Clinton, who said something amazing and scary when I gave it to her. I worked on her campaign, and when she came through on a book tour in 2017, or she was promoting the book that she wrote about the election, and I had some VIP access, and I wanted to give her one of my constitutions. So I walked up, and I attempted to hand her the Constitution, and one of her handlers ran in and tried to stop me from putting something in her hand, but she shooed them away. And I expressed to her that this is something I've, multiple school systems. My old high school, I gave 700 to my old high school students, get them every year. And she looked, she said, this is amazing. And she opens her space. You know what? I've never had one of these. Secretary of State, potential President of the United States, First Lady, never had a Constitution in her hands. If someone like that doesn't have this readily in their hands, you should. I started carrying my copy of the Constitution beginning my first year of college, when I learned about Justice Hugo Black. Tremendous story. Justice Hugo Black sat in the United States Supreme Court for a long time. Justice Black, at the age of 16, joined the KKK, because that's what young men in Alabama did back then. And he joined the KKK, and he was a member of the Klan for a number of years. And then he went to his first lynching. And he couldn't. And he went to school. He finally decided to get himself educated. He went to college. He went to law school, became a tremendous lawyer, became Attorney General for the state of Alabama, and ultimately governor, and then became a sitting Supreme Court justice. And that's a great story. But what was really important is that from the moment he saw that first lynching, when he went to school, he got himself a copy of the Constitution. And he put it in the vest pocket of his jacket. And he carried it with him every day from that point forward until the day he died. And when they put him in the ground, that went with him. Ratty, tattered-eared Constitution that he kept here his entire life. And for someone like that to do it, I can do that too. And I have, and I've done it ever since. And so I express to you, be someone like Black and carry it close to your heart, because if you don't, there are many, many people out there willing to take that away from you. Thank you very much for having me out.